Welcome to Plan on It.
Welcome to Plan on It with attorney Christopher E. Botti, board certified specialist in real estate planning, trust, and probate law, and the founder of Botti and Morrison Estate Planning Attorneys Limited. I'm Leanne Lyon, and today we're talking about joint tenancy. Chris will explain how it works, where it can help, and why it sometimes creates unexpected problems in California families. Chris, a lot of Californians own homes or bank accounts in joint tenancy without realizing what that means. Could you start by explaining what joint tenancy is?
Sure. When you say a lot of Californians, it's by far the most popular form of joint ownership with married people in particular in California, along with non-married people also holding title this way. And what joint tenancy is, it's a form of co-ownership. Baked into that form of co-ownership, which means two people own or more a property together, is this mythical right of survivorship, which means essentially the last person standing ends up owning the property outright. That's why joint tenancy is attractive to a lot of people, because it provides a mechanism, at least on the first death, whether it's a spouse or a co-owner, there's no administration or probate necessary. And so it is the default form of ownership in California for married people and non-married people alike.
So what kind of tax or estate planning problems can joint tenancy create later on?
Well, joint tenancy is not an estate plan, okay? What it is a trap, essentially, okay? So let's take an example of a husband and wife. And they're in escrow, and the escrow officer says, how do you want to take title? And they say, I don't know. What do most people do? And the escrow person will say, I can't give you legal advice, but joint tenancy, okay? And so that's how you typically end up in joint tenancy with real estate. And so you close escrow, you take property title in joint tenancy, everything's going along perfectly. And then when someone dies, okay? So that first death, because of that right of survivorship that's baked into that form of ownership, joint tenancy, there's no probate administration whatsoever. It's really easy when the first joint tenant dies. We don't have to get the courts involved. And so that kind of is the trap, because it lulls people into sleep. And they think, well, it was really easy when that first joint tenant died. It's going to be just as easy when the surviving joint tenant dies. We're not going to have to go through probate. And that's the trap. Okay, so on the second death, that asset, that home, for example, that was once titled in two people's names is now only titled in one person's name because of the joint tenancy aspect of it. And when they die, that house or property is going to go through probate. That's the dead end. And if you don't have a will, then California will dictate where that property goes under the laws of intestate succession, which is a horrible outcome. If you have a will, then it's going to still go through probate. So it's not an effective estate plan. It's only effective as to the first joint tenant dying in a typical situation. But when you hit that second death, that is where the problems start. And so it's not ideal at all. It's not an estate plan.
Well, in your experience, how does joint tenancy interact with California's community property system? And why can mixing the two forms of ownership really cause some confusion?
Well, in California, we have community property, what they call right of survivorship, which is it's just like joint tenancy in that it's the last spouse standing will end up owning that property outright. It has the same trap that joint tenancy has, because on the second death, if you take title as community property right of survivorship, it will trigger a probate process. So community property right of survivorship is the second best way to hold title as a married couple, because there's tax benefits for doing so. But again, it's not an estate plan. And so on the second spouse's death, you're going to have a probate. Okay. And so the best way to hold title in California is, when you own real estate, is with a revocable living trust. So even though it's community property, you put that house into the revocable living trust, and you get your cake and eat it your scenario, where you get the best possible tax outcome along with a estate plan that's going to avoid probate.
But what happens if one joint tenant becomes incapacitated or maybe just unable to manage their share? Can the other owner act for them, or does that require separate legal authority?
Not necessarily does it require separate legal authority, because let's use a bank account as an example. If you establish a bank account with your spouse and your joint tenants on that account, either one of you could theoretically access that account and take everything out of it if necessary without the consent of the other. right? And so it's not a problem when you're trying to access funds in an account. But if you're going to try to take that joint tenancy account and later transfer it to a trust, for example, or change it from joint tenancy to community property for the tax reasons, you would then need a power of attorney in order to do that if your spouse was incapacitated. So you definitely need potentially additional documentation when it comes to changing the character of joint tenancy into another form of ownership, whether it be a trust or community property. So, but by itself, if someone needs to access a bank account and they hold it as joint tenants with someone, that's not a problem, even though they're incapacitated.
I've also heard that many people add a child's name to a deed or a bank account for convenience. What risks do they take by doing that?
The bottom line is when you add a child onto a bank account as a joint tenant or a piece of property as a joint tenant, there's tax implications for doing that. There's lots of reasons why you don't want to do it. Technically, you're making a gift when you do that. You're taking an asset that you control exclusively and you're adding another person to it, another party. And if the value of that gift is in excess of $19,000, which is the amount you can give away tax-free each year without having reported to the IRS, you've got to report that to the IRS using a Form 709, which is a federal gift tax return. So that's a mistake. And most people don't do that, and technically they're in violation of federal law. The other thing that you do, and this is where the risk comes in, it's far more risky when you co-own a piece of property or a bank account with a child, because it's their asset as far as their creditors are concerned, since they now own the property or they own the bank account. If they get into trouble and they get sued, let's say, for example, they have a tax problem or they get into a car accident or they go through a divorce or there's some other type of lawsuit, that asset that their name is on, because their name is on title, is vulnerable to their creditors. So you're taking the risk and now multiplying it significantly by adding another owner, and their problems now become your problems. And you can theoretically lose your house if you have, for example, if you added a child on as a co-owner because that child got into a serious financial problem and they got sued and got a judgment against them, and the house is now vulnerable to their creditors. So that's a huge mistake.
Wow, that's worth thinking about.
It's going to be fixed, though. The good news is that those mistakes happen all the time, but you can fix them. Okay.
Right.
So the key is being aware that you thought you were doing the right thing by making it convenient by adding a child onto a bank account. And there are situations where you might want to consider doing that, but they're very limited and they're on a case by case basis. But the bottom line is if you make a big mistake, you can fix it.
Excellent. Well, how do Medi-Cal rules treat jointly owned property, and can joint tenancy ownership ever affect eligibility for long-term care benefits?
Well, Medi-Cal has its own unique set of rules when it comes to ownership issues, when it comes to jointly held property. So in California, we consider separate property or community property part of the overall estate when it comes to calculating whether or not you can qualify for Medi-Cal. So whether the asset's in someone's name exclusively or that it's co-owned as community property or in joint tenancy, it doesn't matter. If it's owned by a spouse, it's treated as an asset that counts towards eligibility. So putting something into joint tenancy is not going to improve your situation from a Medi-Cal planning perspective. Putting something into community property is not going to improve your situation. It's your asset, and the state considers that a resource. And with proper planning, of course, you can protect those assets. But in and of itself, there's no advantage to joint tenancy versus community property versus separate property ownership when it comes to Medi-Cal eligibility purposes.
So for families who want to keep things simple but also protect themselves, what are some safer alternatives to joint tenancy, like you mentioned earlier, a revocable living trust or a transfer on death deed?
Well, the revocable living trust is by far the gold standard because that trust is going to provide the most protection possible. In that, when you design a revocable living trust, and you set up your beneficiary designations, which is what happens when you pass on, who gets it, you're going to cover contingencies like, well, if that person who I wanted to give a portion of my house to happened to predecease me, I would like that share or that gift to go to somebody else. In the trust, you would cover that as part of your plan. So it goes multiple layers deep. A transfer on death deed will work, but it doesn't have that extra level of planning baked into it where if that person predeceases you, then it's covered on transfer of death deed. It's not. So transfer on death deeds also have a form of administration that's not like a full probate, but there's a type of administration that you have to do with transfer on death deeds in California that make it not as attractive as it used to be. And so I would consider a transfer on death deed as a bad plan B, and plan A should be the revocable living trust.
And finally, for today's episode, for listeners who already have property held jointly, what's the right way to review those titles and decide whether to make a change?
Again, it comes down to, like, we hold title together, whether it's community property or joint tenancy, and understanding that the form of ownership is going to ultimately lead to a probate. The only way truly to avoid probate is with a trust. And so once you realize that you're not set up, that you don't have a plan in place, it's an easy decision. Like, we have a choice. Do we want to get the courts involved, or do you want to opt out? You want to exercise our rights and decide, hey, I understand what this probate process is. I don't want that for myself. I don't want that for my family. Let's do a revocable living trust, and we can eliminate that risk. And that's what it's all about: being prepared, planning, and the peace of mind that comes with being prepared and planning properly.
Well, that is it for today's episode of Plan on It with Christopher E. Botti. If you'd like to learn more about protecting your assets and creating a plan that works for your family, visit bottilaw.com to download the free 2026 Medi-Cal ebook or register for a Botti and Morrison estate planning workshop. Thanks for listening, and remember to subscribe, share, and leave a review if you found this episode helpful. Thanks so much, Chris.
Thank you.
If you're enjoying Plan on It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.